Ladies and gentlemen, I received from our chairman what in Switzerland they call l'ordre de marche, meaning the military order of what I am supposed to address today, which is the Tadic case, Custom and Treaty in International Criminal Law. I have 15 minutes. I'll divide it into 5 small 3 minutes each. First, nostalgia. Second, custom in general, and the 3 others on Tadic case. Nostalgia. I feel very nostalgic being here because I was here at the creation of the tribunal with Nino, who was my friend since we were graduate students, in fact, since 1960. And it is the first time I come to The Hague without having Nino around. It is not only because of his public virtues, but because of his great drive, great conviction, the fact that he was so driven by his empathy for the human beings rather for abstract constructs. And this perhaps explains to some extent sometimes his overdrive, his exaggerations in the thrust to advance the law, to increase the scope and the ambit of protection, and his impatience with the institutional and bureaucratic limitations that weighed on us when we were in the tribunal. I salute my dear friend and colleague Gabi MacDonald, who is here, and who was with us also at the creation of the tribunal. It was a very hard task to start something, I wouldn't say from scratch, but almost from scratch, weighed also by the terrible bureaucratic political constraints of the UN, because we were a tribunal, but they were treating us as a subsidiary organ of the Security Council. And these are almost 2 contradictory characters. Anyway, that was the situation, and I was retroactively so pleased that I managed to participate in this first decision of the appellate chamber. And unfortunately, I think I am the only survivor of it with the passage of Nino. So this is why this is nostalgia. About custom. Ted sent us a paper which he has synthesized now, which is called, I think, International Humanitarian Customary Law from the Classroom to the Courtroom, something. And where he explained 2 approaches. One is the strict approach or the conservative approach to establishing custom, and the other a relaxed one. I never dare to contradict Ted. He is also a very old friend. We taught together in Geneva. We taught together in NYU. But sometimes I can't help at least qualify what he says. We cannot treat custom in the 21st century as it was treated in the 19th century. And in fact, in my writings, I have made clear that we are speaking of 2 different animals, 2 different species, perhaps, of the same animal. In the 19th century, when we were living in a world of voluntarism, international law only the result of the will of the state, individual. Custom is implied convention. So every time you want to establish it, you have to establish the practice, establish the opinion juris, etc. Moreover, it was a wild growth, heterogeneous, You never know where it will come, the precedents. There is no continuity between them. They were ad hoc, etc. When we're speaking of custom here, and particularly in humanitarian law, we are not speaking of that. In fact, even in the 19th century, when we had the Lieber Code, the first instrument, which, what does it do? Every convention we have proffers to codify and explicit pre-existing custom. So we have a kind of a game between custom and treaty. A game between custom and treaty. There are some practices, then we try to codify them, and now we have even a standing organ, the ICRC, trying to further the practice, etc. And then after a few years, we come back and try to put them on paper, and so forth, and so on. And not only that, but we have also a safeguard clause in every one of them, which is the famous Martin's clause, which we find already in 1874 in the Brussels Declaration, but particularly in the Geneva Conventions of 1899 and 2007, which says, for example, from the Hague Convention, it starts to say what is the purpose of the convention: to revise the laws and general customs of war, either with the view of defining them more precisely or of laying down certain limits for the purpose of modifying their severity as far as possible. What is as far as possible? Well, here comes the Martin's clause, saying it has not, however, been found possible at present to concert regulations covering all the circumstances that arise in practice. On the other hand, high contracting parties clearly do not intend that unforeseen cases should, in the absence of a written undertaking, be left to the arbitrary judgment of military commanders. So what do? We have a security net, and the security net is the Martin's clause, which is until a more complete code of laws of war can be issued, the high contracting parties think it expedient to declare that in cases not included in the regulations adopted by them, populations and belligerents remain under the protection and the rule of the principles of law of nations as they result from the usages established between civilized nations, from the laws of humanity and the requirements of public conscience. So here, public conscience, the values that society secrets all the time, tries to pull upwards the practice and determines a kind of a direction in the evolution. And the tribunals here are how you call it, the lady who helps women deliver children, midwife. And the tribunals are the midwives here. And the midwife should not be too strict, otherwise the baby may die. It has to facilitate his coming out to the world. And so between the strict or conservative approach and what he calls a relaxed approach, I think we have to find a midway, not midwife, but midway. Okay, so that's what I'll do. I have about custom in general. Now I come to the TADIC. 3 aspects of TADIC, each 3 minutes as well. The first is the methodology. How did TADIC handle custom? Secondly, what it found on substantive law, and thirdly, the impact. First, about the methodology. And this methodology, I have to say, was followed to a great extent also by the ICRC study on customary international law, which Jean-Marie Henckaerts will speak to us about. But as it happened, I was in the steering committee, as was said, so it's a kind of, again, a family affair. Well, the main question which was there was to establish whether war crimes apply in non-international armed conflict. So, obviously, neither the Geneva Conventions nor the protocols did mention criminalization, not to speak of in internal armed conflict specifically, not to speak of the Hague regulations. So the question was open, and to establish it we had to refer to custom. So how do we find the substance of practice? There is a great difficulty in humanitarian law in establishing custom, which is that most of obligations in humanitarian law are what in Roman law they call obligations not to do, meaning obligations of abstention. How do you establish abstention as an act you do out of obligation rather than out of an act out of volition? That is the difference. When what you want to establish is a positive act, it's easy. Here, with the abstention, you have to depend very much in civil law, at least in civil law, they speak that silence does not speak. It speaks only if it is what in French they call silence circonstancié, qualified silence, meaning silence surrounded by circumstances that gives it, imparts meaning to it. It is in fact silence where you should have spoken. If somebody stands on your foot and you don't say, I, then here the silence has a significance. But if he just passes by you, even if it is prohibited that he passes there, you don't have to protest. So that was the first problem which we had to deal with, is to give significant, what is the legally significant practice that can be taken. Secondly, we are speaking really here of actions in the battlefield mostly. And in the battlefield, there are rarely third-party observers, in a way. It's very much inter partes. So you have to take the word of one or the other part. Again, a great problem of proof. So here you have to look at two things, at least according to Tadic. It's what we call, I don't think it's in, internally induced practice and externally induced practice. And this we took against the background of historical events, particularly two important historical events of civil wars. One was the Spanish Civil War before the Second World War, and the second was the Biafra War in Nigeria more recently, and also some references to El Salvador. What do we have there? Well, in Spanish Civil War, we have a lot of taking of position of third parties, particularly on indiscriminate bombarding. But I have to tell you that during that period, there was a great concern about aerial bombardments in general, because these aerial bombardments were not covered at all by the Hague Conventions, except from bombardments from balloons, where there was a convention on that, a protocol on bombardments from balloons. So, and this is the very interesting thing. So, the positions of the League of Nations, saying that indiscriminate bombardments are against the law of nations, etc., did not distinguish between internal and international armed conflict. It was a general problem and say, in armed conflict, you should not do it. States, individual states taking position, declaring that indiscriminate bombardments is, why do we wanted so much to refer to that? Because here we have a trend which doesn't distinguish between internal and international armed conflict. I have to in Biafra, it's internally induced practice. Why? Because the Nigerian tribunals themselves punished those perpetrators of acts which they considered as violative of international humanitarian law, although it was a civil war. It was not an international war. So it was a kind of recognition by the party on whose territory, and in both cases, that is a very important point, there was no recognition of belligerency. The former government did not recognize the rebels as rebels, and thus bringing all humanitarian law into application. So this is the type of practice. And the second point is that it is not only sufficient to establish that the rule applies both internationally and internally. It was also important to prove that the violation of this rule has been perceived as being a crime. I see that Ted is looking to me furiously. I have to finish. Okay, should I mention the second point, and I forgo the third, we come back to it. The second point, what did we decide in that case? The trial chamber followed the prosecutor by saying, anyway, the Security Council considered this is an international conflict, and we don't have to go beyond that. We will go by that. The appeals chamber said, of course, that was la solution de facilité. It was much easier to go this way, and that would take care of. And there were some aspects of the conflict which were international, but there were some aspects which were internal, particularly in Bosnia, and we were speaking of that. What counted was to say that there are certain rules which apply to both. And these rules are so important that their violation have been considered already as constituting crimes, war crimes. And that is what the court found, what the chamber found, that certain acts, even they were basically violations of Article 3. The acts fell under Article 3. But Article 3 does not speak of criminalization. It speaks only of principles which apply in internal armed conflict. So, in a way, that was a very big hole in the very strong wall between which has been there between internal and international armed conflict. And I'm very glad, because I have been running around and pleading in all fora against all walls, both walls on the terrain and walls in the minds of people. But this hole has been increased. Once you open a wedge, from there on, the jurisprudence has increased it, and then came the ICC and really eliminated a very big part of the wall. What remains is really remnants, a little bit what remains from the Berlin Wall now. And we are going towards a situation where such atrocities in any kind of international, in armed conflict are criminalized. Thank you very much.
Thank you very much, George. George, with his Tajik case, in biblical terms, really represented the book of Genesis. And we are extremely grateful to you. I will now turn to Professor James Crawford, who, as you know, is Hewell Professor of International at the University of Cambridge. I will ask him to broaden our discussion with his unparalleled experience as a scholar and as an advocate, and speak of the role of custom in criminal and civil international jurisdictions more generally. James, we are so happy you could join us today.
I'm conscious that I stand between you and coffee, so I shall be comparatively brief. We're grateful to Judge Meron for setting out what might be described as a theory of custom according to the Yugoslav Tribunal. And he does that in his paper at page 33. This is taken from the published version of his speeches. You have to be a very great man indeed to have Oxford University Press publish your speeches. But of course, there's no doubt about that with Ted. He says, thus customary law can provide a safe basis for a conviction, but only if genuine care is taken in establishing that the relevant legal principle was sufficiently firmly established as custom at the time of the offence, so that the offender could have identified the rule he was expected to obey. And that general proposition, which might be thought to be an emanation of the principle of legality, was also adopted by the court, for example, by the tribunal. For example, in the Galich case, where the tribunal said, and I quote, "The judges have consistently endeavoured to satisfy themselves that the crimes charged in the indictments before them were, I stress were, crimes under customary international law at the time of their commission. This is because in most cases treaty provisions will only provide for the prohibition of a certain conduct and for its criminalisation, or the treaty provision itself will not sufficiently define the elements of the prohibition they criminalise, and customary international law must be looked at for the definition of those elements." There is a certain contradiction in that dictum. The first part of it says that we have to satisfy ourselves that the crimes charged were crimes under customary international law. The second part says this is because we have to have customary international law because the treaties are inadequate. They only provide for the prohibition of a certain conduct by others. They're not self-executing. Or they do not sufficiently define the elements of the prohibition. So customary international law becomes a necessity. And yet if it's a necessity, how certain can we be that it exists independent of our necessity? An element of the definition of the opinio juris, and I stress that as far as we can see that the concept of opinio juris is a 20th century concept, not a 19th century concept, still less an 18th century concept. Opinio juris sive necessitatis, an opinion or a view or a belief as to the requirement being one of law, or being necessary, or being necessary. There are three provisos to this legality criterion of custom, which is formulated by Judge Meron and in the Galich case. The first proviso comes from Celabici, which can be described as the obvious illegality requirement or exception. You don't have to look very hard at custom if the conduct is so obviously illegal that anyone must have known that it was illegal. And one can understand that the moral repugnance at the conduct that's involved in many of these cases is such that you search for some criterion of that sort. But the problem is obviously illegal according to what law? There is much conduct in the world which is obviously illegal, but which international law does not criminalise. An ordinary murder, for example. Somewhat paradoxically, international law criminalises what might be described as an ordinary official torture, but not an ordinary official execution, at least not in all circumstances. So there's the obvious illegality requirement, and it seems that the defendant has to have a lawyer to be able to say according to what law. Perhaps we need to face the reality that what we're doing here is moulding a set of moral imperatives in the exercise of a mandate given, which we've accepted. Now, whether that's consistent with orthodox views of custom is a question to which I'll return. But there comes a point when the material on which we're working cannot bear the weight of the classical requirements of custom. The second exception, he said, dropping his pen, the second exception might be described as the development and clarification exception. It's not a violation of the principle of legality to develop and tease out the implications of a rule if the facts require it. So even though the rule might be somewhat embryonic, it has to be teased out in the given situation, and it crystallises in that situation without necessarily the delineaments of the rule having themselves been established through custom. Alexovsky is an example of that principle. And the third exception, if it's an exception, is that you don't have to go into the rather tedious requirements of examining state practice and the mysterious opinio juris if you have a precedent which has done it for you. So, whereas the common law moved from precedent to precedent in what was said by Tennyson to be a glorious progression, the progression of international criminal law is from practice to precedent, and then precedent can take over. And you can see this methodology being applied in the Hadji Hasanovich case in respect of the principle of command responsibility. Now, according to Judge Meron, there are two elements which underpin this theory of custom. The first is that it is conservative in harking back to the classic conceptions of custom in general international law. The academy from which this classical conception is said to have been drawn, one might say extracted as one extracts teeth, has spent most of its time since the extraction trying to trash custom. And it's now the function of the courts and tribunals to vindicate custom against the academy. The second element is the principle of legality, which Judge Meron identifies as a peremptory norm. Another modern concept, it has to be said, although the term jus cogens does go back rather further than had been thought. Now, what are the virtues of this conception of custom? There are a number of virtues that are identified. First of all, it solves the problem created by international law, or the problems created by international law, for a tribunal in the position of the Yugoslav tribunal. What are those problems? The problems are the complete or virtually complete indeterminacy of the rules of succession. Bosnia, which if ever a state needed succession, needed it, acceded to relevant treaties rather than succeeding. Of course, one doesn't always have a legal advisor to hand when one is a government, let alone when one is a potential defendant. It solves the problem of reservations, because if customary international law is there, you can ignore the manifest problems of reservations, which took Professor Pele 15 years and I think possibly 15 million words to resolve. It resolves the problem of agreements between belligerents, because those agreements are of dubious relevance in this situation where you have custom. And above all, it solves the problem of retrospectivity. And by definition, the sorts of crimes we're talking about are liable to have been committed in states of instability, states both in the physical sense and also in the legal sense, because the states themselves will be in statu nascendi, or at least in a state of transition from one situation to another, with situations of continuity unresolved. The International Court, I think with great wisdom, tried to maintain an equivocal status for the former Yugoslavia throughout the 1990s, only to have it crash in ruins in 2004. In the exercise of this conservative conception of custom, the Meron conception as I'll call it, the Tribunal has actually done remarkable things. I was able to count on a fairly crude estimate 10 examples of significant lawmaking which were presented under the rubric of custom in the field of substance alone. I'm not going to go into them in detail, but I'll mention them briefly. The definition of armed conflict in Tadic, the question of nationality of protected persons in Alexovsky, the distinction between international and internal armed conflict, again in Tadic. And I would mention here, if I may, in a slight sense of paternal pride, a book by someone called Emily Crawford, in which she argues for the complete destruction of the Berlin Wall. Fortunately, views about international law are not necessarily transmitted from one generation to another. Individual criminal responsibility in internal armed conflict, again Tadic. Superior or command responsibility, Delalic, Celebici. Joint criminal enterprise, and it's a remarkable achievement of custom. It's the distinction into three categories of joint criminal enterprise. Never has custom been so finely grained, Tadic in later cases. Enslavement is a crime against humanity. Sexual slavery and cognate crimes, Furunzia. The cross-border element in deportation, Starkic. Again, a conservative case, because quite correctly they said that deportation across a changing ceasefire line is not sufficient. And the official capacity requirement in torture, which was incorporated into the Torture Convention by consensus at the last gasp, in circumstances in which no one understood what was going on, and no one subsequently has been able to understand why that limitation should exist. I've only mentioned the substantive elements. There are many more in the field of procedure. I set this against the approach to custom in general international law. It's often said that the Yugoslav Tribunal is more or less in the position of the Nuremberg Tribunal, having to do something for the first time. And the Academy has made much of the logical problem of how you can have custom when you're doing something for the first time, and how you can believe that something is required when no one has ever done it before. There's a different paradox here, actually, because I think the position of the Yugoslav Tribunal was not the same as that of the Nuremberg Tribunal. The Nuremberg Tribunal was an occupation tribunal, mandated to do a certain thing which was better than the alternative, the famous alternative of shooting the top 100, which was said to have been advocated by Churchill and opposed by that great lawyer Stalin. The problem is the paradox of custom amidst the plenty of rules. And the way national courts have reacted to that is to say, we give up custom because we have an active legislature, which can make rules if we need them, and therefore you get decisions like the House of Lords in the Queen against Jones Margaret, accepting that aggression is a prohibition, is a customary international law prohibition, but saying it can't be incorporated in English law because we simply lack that power now. So what national courts have stopped doing, international courts have to do. It's a curious example of history repeating itself. When we were confronted with in the 90s with the issue of how to go about constructing an international criminal court, there was the first question was whether you took advantage of the acquis built up over 30 years of treaty making from the Genocide Convention on. And what happened? The acquis was practically ignored, especially in fields such as terrorism. And instead we had the reinvention of custom in the form of the Rome Statute. Now this isn't a criticism. It may be an existential element about the transition from an interstate system of rules to a system of rules which is brought to bear on the individual and has to be brought to bear with the requisite determinacy. Since I was asked to talk about civil jurisdictions as well as criminal jurisdictions, and since I will at least briefly comply with my mandate, I should say a word about international crimes of state. When we didn't have much by way of international criminal law except an aspiration which was a residue of the Nuremberg trials and the feeling that we should at least prospectively try to justify this, even if we couldn't do so retrospectively, there was a great deal made of international crimes of state, not least by Judge Cassese. Just at the time this was going on, this massive development under the rubric of custom of general international law, at the same time the International Law Commission was struggling to get rid of the notion of crimes of state and to replace it by something more operational. The Yugoslav Tribunal itself contributed to that in no small extent in its Blaskic ruling. I should say, by way of anecdote, that I lost the opportunity to plead before one of the Lords of Life, if I can use D.H. Lawrence's description, because I was supposed to argue the second day of the Blaskic case before the Yugoslav Tribunal presided over by Judge Cassese. Unfortunately, Judge Cassese had made up his mind on the first day, and the second day was cancelled. The International Court in the Bosnia case adopted the same view. We don't have international criminal liability of states, not because it's inconceivable, but because we don't in fact have it, and we shouldn't pretend we have it. That means we don't have subpoenas for states any more than we have jails for states. A final point about the distinction between civil and criminal responsibility, which is a real distinction. I spent quite a bit of this period, or the period of the last 10 years, arguing about international humanitarian law in a civil context in the Eritrea-Ethiopia Claims Commission, Compensation Commission. The Compensation Commission, which had a bilateral mandate, had to apply customary international law for most of the period because Eritrea had, amidst many other things it had neglected to do, had neglected to ratify the 1949 conventions. And the Commission worked on the assumption that if it was in the 1949 conventions, in particular if it was reinforced in 1977, it was presumed to be customary international law, and you had to prove otherwise. From the point of view of an advocate, this meant that you were in a desperate situation because you had very little time. You had facts to argue. And if you stood up and said, I'm going to argue that such and such a rule in 1949 is not customary international law, that could be taken as admission of responsibility. In those circumstances, there was very little argument that rules were not rules of customary international law. So it may be that we see a different standard of proof being applied to the demonstration of custom in civil and criminal jurisdictions. We need to look at the whole process that's occurred since the early 90s, both with a sceptical eye and with a sense of the values involved. And it's very difficult to do both things at the same time. There was a great cry at the time when the atrocities in Yugoslavia occurred. Don't just sit there, do something. And a skeptic would say that what the international community did through the Security Council was to say, we're not going to do anything, but we're going to get the tribunal to sit here. I think that's an excessively sceptical view. International law is moving away from its purely interstate foundations. And there is a new world struggling to be born, with or without the aid of Georges' midwife. But we have to be realistic. International humanitarian law, which one of my predecessors described as the vanishing point of law, has always had a Martin's clause attached to it. Not because there was custom, but perhaps because there wasn't. Thank you.
Thank you so much, James, for this fascinating discussion. First, I will apologize to you for running late with regard to the coffee break. In my defense, we are all aware of the fact that we started late with the panel. What I propose doing is this: we will have the remaining two panelists now, and then we will have a coffee break. So I turn to Dr. Henckaerts, co-editor of the ICRC Customary Humanitarian Law Project. George and I spent years working with him when we were on the steering committee of the ICRC project on the subject. And I expected that he will provide us with an insider's view on the ICRC Customary Humanitarian Law Project and the special synergy between that project and the jurisprudence of the ICTY. Jean-Marie. Jean-Marie wanted to be away from me in order not to be reminded of the time, so he went far away.
Yes, thank you, Ted. It's a great honor for me to be part of this panel. I'm very pleased to be here and, of course, slightly intimidated by the stellar composition of this panel. So I will share with you some thoughts about the synergies between the ICTY case law and the ICRC's customary IHL studies. So I will address first the parallels in the mandate, and then talk about the synergies in content, and also talk about the synergies or parallels in methodology before making some conclusions. So first of all, the parallels in mandate. Of course, the ICTY was mandated by the Security Council, and the Secretary General's report, as you all know, provided already, set forth that the tribunal should apply rules of IHL which are beyond any doubt part of customary international law. So in May 1993, when the statute was then proclaimed adopted, Article 3 of the statute said that the court could apply the laws and customs of war. So you had customary law from the start explicitly spelled out in the statute of the court. At about the same time, this is the first time I really looked at the dates so clearly, part of the world was also doing other things in Geneva against the background of the conflict in the former Yugoslavia. There was an international conference for the protection of war victims in August-September 1993. So you had the ICTY established in May 1993 with Article 3 in the statute, and at the same time there was this process of the International Conference for the Protection of War Victims, which eventually led to the mandate for the ICRC to carry out a study on customary IHL applicable in international and non-international armed conflicts. So on the one hand side, you had the ICTY just being set up, and on the other hand, you had the International Conference of the Red Cross and Red Crescent, states, in other words, mandating the ICRC to carry out a study on customary international humanitarian law. So there were clearly very significant parallels, very important parallels in the mandate in terms of assessing and clarifying content of custom. Because that's how we have perceived our mandate, is on behalf of states to clarify the content of customary international law, because we all know it's there, it exists, but the exercise of capturing custom, of taking a photograph of the moment of what custom is today, is actually very time-consuming if you want to follow a traditionalist approach and look for a general practice accepted as law, which is what we set out to do. So our methodology was very much inductive. which also explained why it took 10 years to complete the study, because we had to collect practice, to examine practice, and inductively assess whether customary law existed. So on this subject, of course, we can devote a 2-day conference. I've been involved in many discussions on the concept of customary international law. We've discussed what it means to have a general practice, how widespread, representative, and uniform the practice has to be. And generally, we then say there is no mathematical formula. It differs, it depends on the subject matter. Secondly, practice. What does it mean, practice? Is it verbal and physical practice? Is it only physical practice? In that respect, we were able to rely on the Tadic decision, which also indicated that for IHL, practice will very often have to be looked at in the substance, in the content, of military manuals, official pronouncements, national legislations, because information of actual battlefield practice may not be available or may not be correct. In addition, I would say military manuals also at the same time reflect very often the opinio juris of the state concerned. So we have also relied on military manuals, national legislation, and official pronouncements. And thirdly, the third element of the definition of custom, general practice, accepted as law, the so-called opinio juris. And there very often we've been criticized to say that we've taken statements from military manuals out of context and that it does not necessarily reflect the opinio juris of states whenever they put a certain statement in a military manual. And of course, it's difficult to argue with that because no one can actually read the mind of a state if that would exist. But our methodology has been, and our argument has been, to say that we do not look at each and every individual piece of practice, each and every individual resolution or military manual, but we look at the totality of the practice. And the totality of the practice, I think, for each of the rules that we've identified, indicates that we're talking about rules of law insofar as the customary rules are concerned that we've identified. In other words, opinio juris would make the difference between rules of law and practices which are followed as a matter of convenience, or military convenience or political convenience. And so when one looks at the totality of practice, let's say on the subject of pillage, it is clear that the statements, the resolutions, the condemnations, the pronouncements, the military manuals prohibiting pillage clearly indicate that this is a rule of law and not a rule of military convenience or political convenience. So we look at the totality of the practice. The outcome of the study, which was published in 2005, was that we assessed 161 rules to be part of customary IHL, 13 of which applied in international conflict only, 2 applied in non-international armed conflict only, specific rules for non-international armed conflict on reprisals and amnesties, and then the big majority, the large majority of rules, 146, applied in both international and non-international armed conflicts. So this was 2005, 10 years after the famous Tadic decision. And of course, this conclusion, to some extent, or to a large extent, was possible also because of the evolution set in motion and the precedent created by the Tadic decision. So synergies in content and methodology. So obviously in 2005, we were able to rely on the case law of the Tribunal as it had developed up until then. There is a difference between the study and the case law. It was easier for us, in other words, to assess the customary nature of some rules in 2005 because by that time, practice had significantly developed. And I think today, while we continue to collect practice, we see that the rules that we have assessed in 2005 are actually reinforced. Practice continues to reinforce the existence of these rules. Whereas the Tribunal had, I would say, a more difficult task to assess whether custom existed at the time the acts were committed in 1991, 1992, or 1993. Also different is that we looked at the primary rules. Pillage is prohibited, whereas the court had to take one step further. Pillage is not only prohibited, but pillage is also a war crime, and establish that criminal liability attached to such an act under customary international law. The case law of the ICTY has been specifically relevant in our study for the rules dealing with the conduct of hostilities, rules 1 to 24. This includes the prohibition of indiscriminate attacks, the principle of proportionality, and also rules related to precautions in attack, including Rule 2, prohibiting the terrorization of the civilian population, to which I will turn in a minute. Rules 38 and 40 on the destruction of cultural property, Rules 50 and 52 on the destruction of property without military necessity and pillage, several of the fundamental guarantees, in particular violence to life, torture, cruel, inhuman, and degrading treatment, rape, and other forms of sexual violence, and slavery, the rule on forced displacement, several rules on criminal responsibility, including command responsibility, including in non-international conflicts, and also the definition of war crimes, again, including war crimes in non-international conflicts. These rules reflect also, of course, to a large extent, the facts that occurred in the former Yugoslavia, the violations that occurred. Our study covers other subjects, but for those subjects, for example, treatment of the dead, the missing, or treatment of detainees, we found less support in the case law of the ICTY simply because the court did not deal to a large extent with these rules. Just a few highlights from these rules and the cases that dealt with them. What strikes me and what I think is part of the global legacy of the ICTY is that the court, in applying these rules, has applied norms that so far had not been applied in court. Rules related to the conduct of hostilities, for example, the prohibition to terrorize the civilian population, had existed, but as they existed, the specific wording in the additional protocols had actually not been in practice, had not been tested. And I think that is very important. The value added of the case law, therefore, is also examining the contours or the definition of those crimes or those acts. Definition of rape has been mentioned, definition of torture, deportation, the law on command responsibility, and in the case of the Galić case on the terrorization of the civilian population, exactly what it means, what this violation entails. And so the court, for example, found that the actual terrorization of the civilian population is not an element of the crime, that the mens rea of the crime consists of the intention, specific intent to spread terror among the civilian population. This intent can be materialized by direct attacks, but also by indiscriminate attacks or by launching disproportionate attacks. And the fact that other purposes of those attacks may have existed does not mean that the intent to terrorize did not exist. The intent to terrorize can be inferred from the circumstances of the acts or the threats of violence. So I think it is extremely important and part of the legacy of the tribunal to have applied these norms, to give life to them, to show that they actually are relevant, and also to define the contours, the definition, which from a practitioner's point of view I think is extremely important. It is actually bringing the law on the books to reality or from the classroom to the courtroom. The same with the law on command responsibility, and Hadziazanovic has been mentioned. And in this respect, there are clear synergies between the ICRC study and the ICTY case law, because some of these cases were then decided after the publication of the study, and the court was thereby it became possible for the court to actually refer to practice in reality. This had already happened, and also by the Darfur Commission, for example, which later led to the referral of the Darfur situation to the ICC. So what I think is remarkable in this respect is that unlike some other national tribunals or commissions which have referred to the ICRC study's conclusions, the ICTY has actually relied on the practice underlying the study. The rules are only, in a sense, the tip of the iceberg, but underneath those rules, underneath those conclusions, is this massive amount of practice to which the court has been able to turn. And that explains why today we are continuing to update this volume 2 of the ICRC study, this collection of practice, because we think it will continue to be relevant for practitioners to be able to assess customary international humanitarian law. And so we make this collection available online on the website of the ICRC. we have, in that respect, a project based at Cambridge University, which is continuing, and next Monday, we're launching a new update of a national state practice on that database. So these launches go by installments, and next spring we will then launch practice from Spanish-speaking countries. So this is just to underline that the ICRC study on customary international law is not only about the conclusions, the rules of customary international law, but is also about collecting and analyzing and cataloging practice on international humanitarian law. Because without a collection of practice, one cannot use a traditional approach and examine whether widespread practice exists underlying customary rules.
Jean-Marie, I'm afraid.
Yes, I will wrap up now to say that the conclusion that we reached, I think, and the synergies in particular between the case law of the ICTY and the ICRC study is, of course, in the field of non-international armed conflicts. In particular, applying the concept of war crimes to serious violations in non-international armed conflicts and applying the rules on the conduct of hostilities in non-international armed conflicts. And also the rules on command responsibility. And I can understand that criticism has been raised against the ICTY case law because we've also been criticized to say, how could you reach so many conclusions on non-international armed conflicts? How could suddenly so many rules on non-international armed conflict become part of customary international law? Of course, one has to look at the practice, examine each rule in detail, but I would say, to be general and brief, is that this evolution is part of evolution of international law in general. We see that starting with the CCW Protocol 4, which in October 1995 was still limited to international armed conflict, the year after, in May 1996, Protocol 2 was amended to cover international and non-international armed conflict. And every treaty since then, the ICC statute, the Hague Protocol on Cultural Property in 1999, the amendment of Article 1 of the CCW, the Chemical Weapons Convention and the Cluster Munitions Convention, the Special Court for Sierra Leone statute, all of them have been applied in international and non-international conflicts. So we see that starting from 1995, there is also a willingness on behalf of states to apply and to basically tear down the wall between the law on international and non-international conflicts. And we see that also reflected in Security and General Assembly resolutions, because remember what they deal with. These resolutions dealt with conflicts in Afghanistan, Angola, Bosnia, Burundi, the DRC, Liberia, Rwanda, Sierra Leone, Russia, for Chechnya, Somalia, Sudan, Darfur, Tajikistan, Yemen. So all situations of non-international conflicts. So state practice basically caught up with reality and realized that these rules on conduct of hostilities, command responsibility, war crimes had to apply to non-international armed conflict, but it was still, I would submit, through state practice that this transformation took place.
Jean-Marie, I'm afraid that we have to stop now.
So excuse me?
The time is up.
Okay, let me then just conclude to say that, so we've bridged the gap between international and non-international conflict, but of course the gap is not closed. Still differences continue to exist. The wall has been torn down, as George said, but remnants are left. There's still specific rules on competence and combatant status, occupied territory, that differentiate the law of international and non-international conflicts. But overall, the fundamental rules, the basic rules that govern the conduct of hostilities and the treatment of victims today are the same, and that to a large extent is also due to the legacy of the ICTY. Thank you.